Welcome back, ladies and gentlemen. So today we're going to be taking another look at the Chad Daybell case and what the Idaho State Supreme Court had to say about his two upcoming court dates, one in October and one in November. Thank you for joining me today. Welcome back, everyone. So, like a lot of different states here in the U.S., the Idaho State Supreme Court has answered to what we shall do for when it comes to court dates coming forward and going forward, basically, of in cases that are important, like Chad Daybell and Lori Vallow. What should we do? Should we have court in person? Should we have court where it's only done by televised, closed circuit TV, where the defendant and their attorney are in one room, the judge is in another, and the witnesses are in a completely different one? Or can we actually open the courts back up to give each and every defendant their due process and to allow them and the rest of us out here who want to watch the cases, unfold, the ability to actually do that? Well, the Idaho State Supreme Court has ruled the following on the next two court dates for Chad Daybell, starting with October 29th. Chad Daybell's change of venue hearing, this a motion that was filed by his attorney, Mr. Pryor, to change of venue. So he believes that he wants to move his case from where he's at to another venue, and most likely it would have been Boise, Idaho. He wanted to move it there where there was a larger jury selection, where less people are most likely to have formed an opinion about what took place on Chad's actual farm and the crimes that he is currently have levied against him. The Idaho State Supreme Court has decided the following will happen for that case and date. On October 29th, the court case will be televised, number one, which is a good thing because that way we all get to watch it from the safety and privacy of our home, and we can keep up with the case. The next thing that the Supreme Court has ruled is that the court will be open. That is right. There will be people in the gallery. There will be witnesses. There will be those who are there to testify. And there will be a small selected amount of seats that will be available for people to come in and actually watch the case. They haven't said how many, and they're leaving that up to the actual court themselves where the case is going to be heard. But they will have court in process and in person. And they must do the following with their own money. The court there, where Chad's case will be heard, must do the following. They must install plexiglass shields between the gallery and the bench seating, for where people will watch the case, and the actual attorneys and the clients. They must install that. They must install plexiglass shields for the judge. They must also put into motion procedures to sanitize and to keep each and every person safe, which most likely will be they will check temperatures and so on, and as people come into the actual court itself. And that is for the October 29th. They must have all these procedures in place before October 29th, before they can actually have that actual court date. Now, the same thing basically goes for the November 24th, which is the motion to dismiss the charges against Chad. That is the date where his attorneys and witnesses will testify on what has been known, what is factual at this point, and why they need to go forward on this case and why it shouldn't be dismissed. Yes, I know. Chad's attorney, Mr. Pryor, is asking that the case be dismissed after they change of venue. kind of weird, but that's the way that the court cases actually came up, because the state Supreme Court, along with the Idaho courts there, are answering them in the order that the motions were actually filed. So Chad will have his day in court for the next two, and both of them will be done in person, and there will be witnesses that will testify, and it will also be televised. So we do have both of those court case dates still in motion, and we will hear and see Chad and his infinite wisdom there in court again. So I know this is a quick wrap up of those two, but I wanted to get this video out and let you all know that both of those motions have been answered by the state Supreme Court, and court will now, and not only just Chad's case, but going forward now, here on out, cases will start to be heard in person. They will not be locked away behind closed circuit TV. We will actually get to hear witnesses, and we will get to hear and watch what takes place in this case and in a lot of other cases that are going on here in the United States. But first off, just in the state of Idaho, each state has the ability to put the procedures and protocols into place to keep the courts going, because the backlog that has been building up in every single state across this nation is unbelievable. I'm taking into account just my county alone. According to the district court here and where I live, they have in excess of 2,000 cases that have yet to be heard in any fashion at all, not by closed circuit TV or in person. There, where Chad and Lori are, they have 816 cases that are backlogged right now. And the wheels of justice have slowed to a crawl in so many different locations across the United States. They just cannot proceed because of the coronavirus shut courts down. So thank you for joining me today for this quick little video on this. I hope you are all staying safe out there, and I'll be back in swing the rest of this week on everything else. Thank you for giving me the time to deal with life out here on the other side of this camera. You stay safe out there.